Welcome back to the Law and Crime Network. I'm Heather Hansen, and we have got a doozy of a trial here for you today. It's a case that's being tried in Florida. It seems many of our cases are tried in Florida, and this case is Florida versus King, Barrow, and Smith. Now, one of the things that I know that you trial watchers are already chatting about in the chat rooms is that with multiple defendants come multiple defense attorneys, and with multiple defense attorneys come multiple closings, multiple openings, multiple cross-examinations. And you know, Addie pointed out that this morning's openings were not as confusing as she thought that might be. When all the defense attorneys are working really well together, we can find that it can actually work well for the defense and for playing out the case. But we have a criminal defense attorney from Florida here as a guest for us this morning. Andell Brown is a criminal defense attorney based in Florida and here with us via Skype. Good morning, Andell.
Good morning, Heather.
It's so great to have you here, someone who practices there and has a real sense of sort of what goes down there in one of our southern states. I want to start with something that I'm just fascinated by because I have never tried a case with this, and that's multiple juries. And I think that you said that while you're familiar with it, you too have never tried a case with multiple juries. Isn't that right?
That is right. Most of the time, either you're going to try it with one jury or you're going to sever and have separate trials. This multiple jury thing is very unique for this case.
It's an unusual thing. I actually did some research on it because I was so interested in why they would do it this way, and it had a lot of things that concerned me. Apparently, it's quite unusual. It's something that's only done in some of the states and in federal court, and at least as of the late 90s, which is the last article I could find on it. But what the reason for it, according to what I've read, is for efficiency and for financial reasons. So for example, in this case where there's scores of witnesses that have to be called, rather than have two trials and sever it, as you noted, they will actually just try it once and have two different juries, or I guess it could have even been three different juries to decide it. I see so many problems with this, Andell, but what do you think overall of the idea? And then we'll get into some specifics.
Well, I mean, it sounds like a logistical nightmare if you ask me, but hey, I'm not in charge of the courtroom there. As far as getting a fair trial and the jurors hearing what goes on, my concern would be that all of the shuffle, all the moving around, in and out, wait for this, wait for that, it breaks up the flow of the trial, it breaks up the flow of the testimony. Jurors have to wait a long time before they can get back. Their recollections may kind of change over time. There are 48 witnesses listed last time I checked, at least 48 civilian witnesses last time I checked. So there's a whole lot that's going on there. However, I think the aim was to make it so that if there is a portion that one jury is not supposed to hear, they can be removed, the testimony can go on, and then you bring them back for the appropriate part of the trial.
Yeah, that's the theory, Andell, and it's fascinating to me because that's exactly the reason they do it. So say, for example, and I don't know this to be true, but say it is the defendant King who has the separate jury. The other two defendants, Barrow and Smith, share a jury. So say King made some sort of statement or some sort of confession that can be admitted against him, but can't be admitted against Barrow and Smith. What will happen in this case, and we'll have to watch for it, is the judge will allow those jurors who are deciding the fate of Barrow and Smith to leave the room, and the testimony regarding King will go forward in front of King's jury, and then those witnesses will come back in. But Andell, wouldn't you be concerned about whether or not the jury is missing other testimony that they should be hearing? You know, you can't just parse out that one little bit of testimony that only should be heard by one jury. These things are conversations with your witnesses, and I would be concerned that you'd have to repeat yourself every time you brought the jury back in.
Well, it appears that it's about a very specific piece of testimony in regards to that witness. I believe there was a statement that he's alleged to have made. If you look in the arrest affidavit, they talk about it to someone he confided in and said, hey, I was involved in that thing. That would be the only part that would apply here. All of the rest of the testimony should be heard by the jurors. And so I think it really applies to only a very limited portion of the testimony. They shouldn't really have to repeat anything else. That testimony, that purported admission, only involves one defendant. It doesn't involve the others. It's irrelevant and would be prejudicial if the court were to allow that into their trials.
And I think that's one of the things, many courts, I looked it up, and there, as far as I could tell from my research, has not been any case overturned because there were multiple juries. But one of the things that many judges and many legal scholars have been concerned about is exactly what you said, that, one little piece of testimony that should absolutely not be heard by one of the jury will somehow get out. I would also be concerned, just in human nature, if both of these juries are sort of eating lunch together and hanging out together during breaks, that there might be some cross-contamination of the juries. Do you think that's something that they should be concerned about?
To me, that is the biggest concern, because more than likely these jurors are going to be spending time together. They're sitting next to each other. There may be, note taking and other things like that. The allegation that there's an admission by one of the defendants is a bombshell allegation, especially in a trial like this, where I haven't heard the prosecution say anything about physical evidence. I haven't heard them say they have any forensic evidence. So it doesn't appear they have a smoking gun. This admission is a big deal. And if one of the jurors from the other two defendants hears about this from the jurors that only apply to King, this could change things.
Yeah, I mean, it's definitely something that's concerning. The other thing, I have to interrupt us and take us off topic totally. Everyone wants to know what your pin is, Andell. What is your lapel pin? You have a lapel pin. What is it? What does it say?
That is from Oakwood University. That's my alma mater down there in Huntsville, Alabama, where I went to undergraduate.
Fabulous. Now everyone can focus on our conversation, but they're loving your lapel pin, and you men don't get as many opportunities with your accessories as we do, so I wanted to make sure we gave a shout out to your university. Now everybody can focus on. I do also want to talk to you about the deliberations for two separate juries. When you have two separate juries deliberating, and I read about a case this morning where this actually happened, one jury may come in way before the other jury does, or have questions that the other jury doesn't have.
Absolutely. That's something that the defense attorneys and the judges are going to have to figure out. I don't see how it prejudices any of the defendants, because obviously that's your concern as a defense attorney. Does the way this process is going, is it prejudicial to my client? Is it somehow going to lead to an unjust result? I think as long as the jurors are deliberating, because in most cases we have alternates anyway, right?
Yeah.
In most cases, you have jurors that are sitting there that are not going to be there for part of the process. So we know people are going to come in and out. We know there's certain things that some jurors will hear and others won't. We're okay with that. In this case, the fact that they may end at different times, I don't think it causes a problem at all.
Just to repeat for Sybil, who I think came into our conversation a little bit late, asking why there's not separate trials. It's my understanding that that's really for financial and efficiency reasons. Is that your understanding as well?
Yes, I think because of the amount of witnesses, the number of videos, manpower for the police, and also court staff and other people, they're saying, look, we're not going to spend this one, possibly three different times. They said we're going to get this done once, and if there's a portion they're not supposed to hear, we'll take them out. If there's another portion, we'll bring them back in.
Yeah. Now let's talk about when there's multiple defendants, because that's something I know both you and I have actually dealt with when we're defending cases where there's co-defendants. What's your overall take on that? How do you like it as a lawyer, and how do you like it as far as strategy for your client?
Well, you can have a situation where the defense attorneys may feel like our interests are somewhat aligned, and they may be sharing information and strategies, or you may have the situation where it's every man for themselves. Because in a lot of these cases, especially more serious ones, as I'm sure you know, Heather, especially in federal court, everybody's flipping or turning on the other. They're testifying against the other people to get themselves out of trouble. In a case like this, you want to be very aware when you have other defendants, whether or not they're working for your interests or against your interests.
Yeah, and it really serves the defense. And if, facts and the truth will sort of rule the day here, but it really serves the defense if you can all work together, doesn't it?
Absolutely, especially in a case like this. I looked at the information, the charging document, and they're charging all three of these defendants with the murder, right? They're saying all three of you guys are responsible, but only one person realistically could have done it. There are three different firearms they claimed with multiple shots. I haven't heard the prosecution clearly state who did what. Who fired the shot that killed her? Who fired the shot that hit this person or that person? So now you have three different people, three different guns, chaos and confusion. It's going to be difficult for them to prove beyond a reasonable doubt who did what.
Right, and that's what the defense is relying upon. And so in this case, we get to watch these defendants almost ganging up on the prosecutor. And that's something that when you can make that work, it can be really effective, because for every witness, the prosecutor will do their direct examination, and then they get 1, 2, 3 bites at the apple of cross-exam, right?
Absolutely. And, you know, it's also a matter of focus. All three of the defense lawyers are focusing on what the prosecution is doing or isn't doing. That's only one person to focus on. Whereas the prosecution, they have to react and deal with three different defense attorneys coming at them. So yeah, it's a situation that can go to the benefit of the defense. But also, since the prosecution has the burden, they typically have way more significant resources than the defense does. They have a lot more information. They have access to police investigators and other people like that the defense just doesn't have.
That's right. It's an opportunity really for the defense to, because oftentimes I know for myself, if I sit down after cross-examination, there may be that one question that I'll say, oh gosh, I wish I had asked that question. And if there's another defendant after me, I can slip them a note and they can
slide
get
that note down.
That's right. That's right. Make sure, as long as the question gets asked, I have no ego about who does the asking. Absolutely. And it can be really effective. When it comes time to put on the defense case, Andell, do you worry about the jury getting repetitive for the jury? Do you really try to work with the other defendants? When you have a combined defense that's actually working together, do you try to work together to limit the testimony and make sure you're boom, boom, boom and getting them up and off?
Absolutely. You don't want to turn off the jury by making it seem like you're beating a dead horse for hours upon hours. Because trial is as much science as it is art, right? You have to keep your jury engaged. You want them to have good feelings when they think about you as the attorney or your client, to the extent that that's possible.
Right.
So you don't want to seem as if you're just up there just keeping them here. They're away from their families. They're away from their businesses. There are other things that they want to do. So they want to feel as if whatever's being done here is important, that you're not wasting their time. That's the worst thing you can do, is make a jury feel like you're wasting their time. And I think the defense lawyers are going to try to keep it tight and concise.
I agree. I mean, I think thus far this is going to be one of the most interesting cases that we've had here on Law&Crime, because of this multiple juries, multiple defendants. And I want to talk about this, the body cam and the dashboard cam evidence. You know, so much in politics lately, there's been talk about, should we have these body cams, should we not? But here's a good example of where, even when we have the body cam evidence and even where we have the dash cam evidence, it doesn't always tell the whole story. There's still, you know, we don't see the shooter. We don't see exactly what went down every step of the way. And one of the police officers actually testified that it was on his chest and not his eyes. And so therefore it only shoots what his chest is pointed at. Do you think that the dash cam video in this case is a make or break for either side?
No, I don't think so. As you know, Heather, the officers at the time, they weren't on the scene. They were involved in a traffic stop a couple hundred feet away, so that wasn't their focus, and that wasn't what the body cam was focused on. So by the time they get there, it's the aftermath. We see people milling around outside of the club. We see the deceased on the ground. The officers are trying to treat her. We see the chaos that's going on. I think that is important for one of the theories of defense for the defense side, because their theory is that with all this chaos and confusion going on, the witnesses that may say they saw one of our clients with a firearm, they can't be trusted. That recollection isn't dependable. There's all type. There are people running. There are people screaming. They're under very high stress. So I think that's where it's important, because when we look at these body cam videos, we get a visual depiction of that chaos that the defense is going to be hammering home.
Yeah, and I think it's fabulous. I think it's a fabulous thing, and I think that in general, I'm a proponent of having them because I think that it's always better to be able to tell a more full story. Even if it's
Absolutely.
missing pieces, it's better for both sides. If you truly believe in justice and want justice to be served, as much as you can provide to the jury to see what was being seen and hear what was being heard, the better. We do have a question, and I love this question because it's a great one for going forward in this case. N8 wanted to know if one of the defendants is allowed to object to a co-defendant's question. Why don't you answer that question, Andell?
All right. If there is an objection to be made and it's legal, anyone can make it.
That's right.
However, for order's sake, the judge is going to tell them, when this person is talking, you can object. When this person is talking, you can object. But I think if there's a legal basis, feel free, object away.
That's right. And a lot of times in my cases, you'll see all of the defense attorneys popping up at the same time with objections because we all sort of have that instinctual, it's coming, there's something to object to. But yes, N8, I mean, Andell is 100% right. You can, if a co-defendant, especially in those cases that Andell pointed out, where you're at odds with your co-defendant, when you're fighting with the co-defendant, you might see a ton of objections from co-defendants' questions, right, Andell?
Oh, you got to be ready. You got to be ready because their interest and your interest can be in two different directions. So your lawyer can't take a question off. They have to always be ready, waiting, listening for that prejudicial or that objectionable evidence that they're trying to bring in.
Yeah, I mean, it oftentimes when you're not working together, you've actually got multiple adversaries as a defense attorney. You're fighting against the prosecution, but you're also fighting against your co-defendant. And then you might be spending a whole lot of time doing some objecting. I want to talk to you also, Andell, about the fact that there are live victims. So many times in our cases that we cover, they are the cases have to do. I think we may have lost Andell. Guys, did we lose Andell? Oh, he's back.
I think I'm back.
All right, fabulous. I'm going to repeat my question, Andell, to make sure that we get the whole thing. But so many times here at Law&Crime, the cases that we cover, unfortunately, they're murders, and so we don't have the victims to testify. But here we have some of the people who were shot to come and testify. How does that impact your strategy as a defense attorney, and how does that impact the way that the case sort of grabs the jury?
Well, obviously, people that have been hurt, anyone that's suffered is always a very compelling witness, right? But I think the theory does not change for the defense. This is all about credibility in the middle of chaos. We have a war of the witnesses. The defense has listed witnesses that they say will tell you that their clients had nothing to do with what happened. They didn't have a gun. And then they're going to have witnesses on the other side that the prosecution will present that say, this person did this person did that. And both sides have admitted that there will be conflicts in the evidence. People are going to talk about things from their perspectives, and it's not always going to match up perfectly. So here with these witnesses that may have been shot or whatever they've suffered, I think the theory remains the same. It's all about credibility. Did they have the opportunity to observe the things that they're testifying about? Is there any bias? Because we had two groups of people that really set this whole thing off. Two young ladies had a long-standing dispute, and then their families got involved. Are they from one of these two sides? Those are the things you have to look at.
Yeah, and it's to your point, the victims certainly, if you've been shot and you've got this sort of melee going on, which I think the defense attorneys did a great job of sort of painting that picture for the jury, then the credibility issue becomes a huge one. And let's talk a little bit about eyewitness testimony in general. When there isn't a melee going on, when people haven't been drinking, when things aren't hysterical, when it's not late at night, even then, eyewitness testimony is inherently incredible, isn't it?
Yeah, it's been proven to be unreliable time and time again in many different cases. And that's why I was very shocked to kind of see that the prosecution's case mostly rested on eyewitness testimony.
Yeah, it's this case is certainly, and it's one, so many cases at Law&Crime we all feel are slam dunks. This case is not a slam dunk for the prosecution, is it?
Not at all. I think it's tough for them to prove guilt beyond a reasonable doubt for these three defendants. I think that if I was a defense attorney, I would be asking, or I'd be posing to the jury, back in the 80s, they had the Wendy's commercial, where's the beef? where's the prosecution's case?
That's right. That's right. I think that that's a very good point. We had another question, and I think this is a good question just in general. I believe that the idea of questioning jurors, whether or not that's admissible, that's allowed, depends on the jurisdiction. Is that something that's allowed in Florida? Is it up to the judge? I know that in the places where I practice, it's not allowed. But what about Florida?
When you say questioning jurors, you're talking about the attorneys questioning the jurors?
No, I'm sorry. For the jury to send up questions to the judge, like we know in Arizona during the Jodi Arias case.
Yes. I know what you mean. When they're actually asking questions of the witnesses, that's not something that's typically done in Florida. Usually the attorneys handle it on both sides. The judge may interject a time or two. The juror questions come during deliberation here.
Right, and I think that's most jurisdictions. I think it's unusual to have the jury with the option to ask questions. Now, our chatters love that, but as a defense attorney, Andell, how would you feel if you were practicing in one of those jurisdictions? And then I'll give you my 2 cents.
Yeah, I wouldn't have a lot of fun with the juries asking questions.
Me either.
I'll take it from here. I'll guide you where you need to go. Hang on for the ride. I got this.
That's so funny, and it's so great because the chatters are like, we love that idea, because of course they would want to be asking the questions too. But I agree with you. It makes me awfully nervous that they might go down a path that is not the path that you are trying to lay for them. And also, I guess there's something to be said for them to you can hone your case around what it is that they're asking. But man, as if it's not something you're used to, it would definitely make me nervous.
And that would throw you off. And of course, as a lawyer, you're always interested in what's going on in the mind of the jury. So, the flip side would be, hey, at least we know what they're thinking about. But I would rather just stay away from that area altogether.
I want to sort of close up our conversation going back to this multiple jury thing. As you can tell, Andell, I'm a little bit obsessed with this whole idea. But one of our chatters, Sky, just made a really good point and said that confusion is a defense attorney's best friend, because if you're confused, then you must have reasonable doubt. And she feels, and I tend to agree, that multiple juries may add confusion to the process just inherently. Do you think that's true?
I think that's definitely a possibility that it could. As I stated before, I think the logistics of it just isn't good for a streamlined, tight case. And as the prosecution, I would prefer to be able to present the evidence, as tight and as concise as possible. This goes to the defense side.
Andell, I want to thank you. Our chatters really enjoyed your insight and your commentary, and we'll be sure to have you back on. I want to thank you so much for being with us here today. I'm going to throw it to a clip in just a minute, but thank you so much, Andell Brown.
Oh, thanks for having me. Have a wonderful day. Bye-bye, Heather.
All right, ladies and gentlemen, we are waiting for them to come back from their lunch break. And while we do, for those of you who weren't able to watch this morning, we're going to continue with the testimony of the first detective who was on the stand. He was wearing a body camera on his chest, and you'll hear his testimony about what that camera caught and what he saw that day. And much of this is doing exactly what we spoke about with Andell Brown, and that is setting up the fact that there was some confusion, that there was some hysteria, that there had been some drinking, and certainly, to Sky's point, putting some confusion in the minds of the jurors, confusion that may be helping the defense in this case. So we'll continue with that clip and we'll be right back.